No, I don't think she has, sir.
Okay. Okay. So because I'm going to send the YouTube channels link on your chat box now.
All right, sir.
And like I discussed with you earlier, you can also monitor the.
No, I don't think she has, sir.
Okay. 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 So because I'm going to send the YouTube channels link on your chat box now.
All right, sir.
And like I discussed with you earlier, you can also monitor the.
No, I don't think she has, sir.
Okay. 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 So because I'm going to send the YouTube channels link on your chat box now.
All right, sir.
And like I discussed with you earlier, you can also monitor the.
Dr. Adedokun, good morning. Thank you so much. I want to join.
Okay, so I've sent the Zoom the YouTube link as well. I've forwarded to their chat box. All right.
Thank you. So
All right.
you can make me co-host or you can exit. I'm being so conscious of joining early so that those students will not log me out. So good morning, everyone. We are 2:14 now. Let's wait till we reach 300. Then we keep start the class. Good morning, and once again, how has been your week? I trust it's going on fine. So you're welcome to TORTS class this morning. Kindly mute your.
Yes, ma'am. Thank you, ma'am.
All right. Lawrence. Who are my culprits in this class? Lawrence was the last person. Lawrence. Omole. How can I ever forget Omole?
It's Lawrence, ma.
Michael.
Eh?
It's
Who
Lawrence.
else?
Emmanuel.
After Amole is Lawrence.
Omole was the
Omole
last
was the
person.
first one. Omole, Lawrence, Michael. The guys are the one causing my class to be in chaotic situation. I don't know what I'll do to them. Okay. So let's mute ourselves now. Let me give you 1 second to mute yourself so that you will not join the you will not join the bad people. Okay, so we started the class last week. Let me just check something. Let me see how many classes I have with you. After this, I think I have just 2 more. Let me. All right. After now, I have 3 more classes. So we are still on course. Okay. We started this class, we talked about trespass to person. We talked about in your introductory class, when you're being introduced to law of torts, I believe you are taught about a number of liabilities in tort. Liabilities, the mental element in thought, you have the negligent, you have the intentional, you have the street liabilities. A number of them. You have the intentional ones. So trespass to person, we are dealing with it as a specific tort. Trespass to persons. And we have said that it's an intentional interference with the person of another one. An unlawful intentional interference with the body of another person. It could be in the physical person. It could be a restraint on the person's liberty, an invasion of another person's. And when we talk of trespass to persons, there are 3 forms that we're going to be dealing with. We've dealt with 2. The first one is assault. The second one is battery. And the third one is false imprisonment. When we talk of assault, putting a person in the fear of bodily harm, the apprehension of that somebody is going to hurt you, a threat that you are vividly, and we talked about the reasonable person. Then we talked about battery. Battery, there must be a touch, a contact, force or bodily harm. And it could be direct, it might not be direct. I gave you quite a number of cases for you to report. Azan and Tade, registered trustee of RCCG and Bankole, Lawal and State, RTLCM Onishano, Kolonji. I gave you Gwaji for Anuwa Kolo. We talked about battery. We talked about the application of force, even however slight it is to the person of another, hostilely or against his will. It's the intentional application of force. We talked about the essentials of it, unlawful application, however slight the degree. Some form of contact, it has to be some form of contact, either direct or indirect. Then bodily injury need not occur. Then the trainer must have acted intentionally. So then at times we talked about battery also, that it's not only hostile interference or hostile touch. We talked about Omole trying to kiss, who is the lady now? And if you just give her a kiss, it's not hostile. However, it's battery to be considered as battery. We talked also that at times you could commit battery to somebody that is not conscious. So, okay. I think the last one we talked about is that omission may also amount to battery. When Lawrence drove his bicycle and accidentally stepped on Michael. And Michael told Lawrence, please remove your bicycle, and Lawrence refused or omitted to remove the bicycle on the foot of Michael. So Lawrence will be guilty of battery. So now we are moving fast. We are going to false imprisonment. False imprisonment. Okay. As the name implies, false, something not real, something not true. Then imprisonment, something that is confining you, something challenging your liberty, something making you not to be able to go where you want to go. Now, false imprisonment is denying a person freedom of movement or personal liberty without lawful justification. It is the total restraint of a person without lawful justification. It is the unlawful bodily restraint, imprisonment, or arrest of another person. It is the restraint of another person without his consent and without lawful justification. So any detention, bodily restraint, denial of personal liberty, or movement, freedom of movement of a person in any place and in any form without lawful justification amounts to false imprisonment. Therefore, any unlawful bodily restraint or confinement of a person, however short the period of time, is what we regard as false imprisonment. Now, we use the word false imprisonment and we say it is false because it is not right. That's the reason the word false is used. It is a wrong done to the person who is restrained. So false imprisonment to a person is a breach of a fundamental right to personal liberty, to personal freedom that is guaranteed in Chapter 5 of the Nigerian Constitution, 1999 Constitution, and by the Constitution, of course, of every other country that is practicing democracy and human rights. It includes detention by government as well as detention by private person or individual. So essentially, false imprisonment could be committed by the government or even by a private person or individual or agencies of the government. The act of false imprisonment must be direct. Unlike what we saw in battery that it could be direct or indirect, but this one must be direct. Though it is immaterial whether it was done intentionally or negligently. So it is immaterial whether it was done negligently or intentionally. Therefore, any unlawful bodily restraint of a person in any place or form from any place against his will may be false imprisonment. And like assault and battery, false imprisonment is actionable in itself without the person or the claimant having to prove harm or damage. You can see that the thought of assault, the thought of battery, and the thought of false imprisonment, they are thoughts that are actionable per se. They are actionable without the claimant or plaintiff having to prove that they've suffered loss, they've suffered damage, or they've suffered injury. You will see things that it's like the opposite of when you start doing negligence, because negligence as a thought is not actionable per se, whereas false imprisonment, battery, and assault, they are actionable per se. So it is immaterial whether you don't have to prove that you suffered harm or damage. Imprisonment usually means locking up a person in jail. But in the context of false imprisonment, the term imprisonment has a much wider meaning. You know, when you talk of imprisonment, you think that you're locked up in police cell or you are in the correctional facilities. But when you talk of imprisonment in thought, under false imprisonment, it has a much wider meaning, and it includes any physical restraint of a person in a locked or an open space, such as in a street. You know, there could be false imprisonment even on the open streets. Now, if you look at some scholars, let me read what a scholar said. He said, every restraint of the liberty of a free man is imprisonment, although he be not within the walls of any common prison. That's what Sir William Blackstone, 1723 to 1780, said. Another jurist said clearly, and this is Black, he said that every confinement of a person and imprisonment, whether it be in a common prison or in a private house or in the stock, or even by forcibly detaining one in the public streets, he said it's false imprisonment. So when you talk of false imprisonment, it's not necessarily that the person was detained in a house or in a prison. 1 minute. All right. I have to mute myself to quickly say something so that I won't be the next example. If not, I'll just be the one making myself the example in the class. So I quickly muted myself. Okay, some of the characteristics of false imprisonment. Number one, depriving another person of his right to liberty, personal liberty, and freedom of movement without just cause. Depriving another person of his right to personal liberty and freedom of movement without just cause. That's the first one. Another one is compelling a person to remain where he does not wish to remain, or to go to where he does not wish to go. Compelling a person to remain where he does not wish to remain, or to go where he does not wish to go. So if Michael insists that Lawrence must stay in the class against his will and against his wishes, that is false imprisonment. Another one is restraint. Now, restraint need not be in any cell or prison, but may be even in the open streets. The restraint need not be in any cell or prison or correctional facility, but may be even in the open streets. Number 4, also there need not be battery. You understand what I mean battery? There need not be any physical touch or any physical restraint. Number 5, the use of authority, any influence, order, trick, or request is sufficient, so long as the person is available to his captor. So you can use authority, you can use influence, you can use order, you can trick or request. All this is sufficient so long as the person is available to his captor. Number 6, the person need not be aware that he's being detained at the time when this is occurring. Though the plaintiff need not be aware that he's been falsely imprisoned. Okay, Then the last one is number 7. The restraint must be total or complete. The restraint must be total or complete. Now, let me go back to number 6 before I give you number 7 again. When I said the person need not be aware that he's being detained at the time. See the case of Merrin against Graham White Aviation Company. Merrin. Merrin is spelled M-E-E-R-I-N-G against Graham, Graham, Graham White Aviation Company, 1919, 122 CL at 44. So number 7, the restraint must be total or complete. See the case of Birds and Jones. Birds, as in birds flying in the air. Bird and Jones, as in Adeniyi Jones. Bird against Jones. 1845, 7QB 742. Now, let's speak to the specifics. Wow, we have a lot to do. We need to run because I must finish this today so that we can start the other ones. So let's start with the first one. We're going to be picking specific things and talking about it under false imprisonment. Number 1 is the first one we're going to be talking about is confinement is not necessary. Confinement is not necessary. Like I said, for there to be false imprisonment, there need not be confinement in a prison or in a police cell. The mere holding of arm of a person as when a police officer makes an arrest in the open street is sufficient. Therefore, one may be confined or falsely imprisoned in a house, in a vehicle, in a cell, in a prison, in a mine, in a street, estate, or in a specific locations or locality, such as a district or province, so long as the restraint is complete and the person is made to remain where he does not want to remain, or to go to where he does not want to go. The intention of the defendant, the tortfeasor, is irrelevant. Your intention as the defendant for falsely restraining somebody is irrelevant. Now, the state of mind, that is the intention or malice of the tortfeasor or the defendant, is irrelevant. Once there is an act of false imprisonment, the tortfeasor, the defendant, is prima facie liable in the absence of any lawful excuse or lawful justification. Therefore, where a tortfeasor, I hope you know what we mean by a tortfeasor. Somebody should just respond. I hope you know what a tortfeasor is, because I'll be using that word.
Yes, ma'am.
Okay, so a tortfeasor is the defendant, the person who has committed, like the criminal now. Let me use the word, the criminal, but you don't use criminal or the accused in tort. You use a tortfeasor, you use a defendant. So where a tortfeasor recklessly or negligently locks a door or allows a door to be locked against another person, he will be liable for false imprisonment, even though he did not know that there was a person in the room or in the house. Therefore, any unlawful restraint of personal liberty, freedom of movement, or arrest of a person without legal authority is false imprisonment. An arrest without lawful authority, when somebody is arrested without lawful authority, is a false arrest or a false imprisonment also, because it restrains a person's personal liberty. So any person who takes away another person's liberty in these manners may be sued in tort. for false imprisonment. So let's talk about the purpose. The purpose of the law of false imprisonment. The purpose of the tort of law false imprisonment is to protect the right to personal liberty and right to freedom of movement. You know, as we mentioned, that's provided by the 1999 Nigerian Constitution. Therefore, the purpose of the tort of false imprisonment is to protect this fundamental right to personal liberty and freedom of movement from being taken away by either the government or any other person. If not, all the powerful people will just be restraining people using their big power. Now, the presence of ill will, the presence of malice is not a relevant element to these thoughts. However, where intention or malice is proved by a party or by the claimant, punitive damages may be awarded in addition to compensatory or nominal damages. Essentially, motive or malice is irrelevant. You can bring action, like I told you, is actionable per se. You need not put proof damage or injury. Also, you need not prove that there is a malice or there is a bad motive. However, when you're able to even establish that there is a bad malice or bad motive, you're going to get more compensations, as in you'll have punitive damages in addition to your compensatory or nominal damages. In the case of John Lewis and Co. Limited against Teams is TIMMS. In John Lewis and Co. Limited against Teams, 1952, AC 676HL. Well done.
Let the God and see. He went to semi final. He dropped the 200 meters. He's just okay. He went to semi final. He dropped the 200 meters.
Hey, Anyoku Chiedu. Chiedu Anyoku.
Oh, sorry, ma.
Hey. You are in Alaba market. I don't have any problem with that. Receiving lecture in your shop or in your warehouse, but you shouldn't disturb my class.
No, I'm just sorry, ma. It's an accident.
It's an accident. Chiedu
Yes, ma'am.
Anyoku. Okay. You are my next example. In fact, you are my major example from now until I find another culprit. Now, I said you should look at John Lewis and Co. Limited against Teams. Now, in that case, the plaintiff, a lady and her daughter, were detained for some time in a supermarket by security men on suspicion of shoplifting. It was later discovered that she was innocent of the suspicion. And of course, she brought an action. The House of Lord held that there was false imprisonment and she was entitled to recover damages. So I think you understand now. Now, the following cases may also may be instructive on this topic. I'll give you some cases. In some, I will explain. In some, I will not. Look at, hey, how do I pronounce this one? No. God will give me the grace. Maybe I'll pronounce it and I'll spell it. Kuchen Mesa against Home Office. Kuchen Mesa. Let me spell it for us. Kuchen Mesa. KUCHENMEISER. Kuchen Mesa against Home Office, 1958, 1QB 496. See also Collins and Wilcock. I think I've given you this case before. Collins and Wilcock, 1984, 3 all ER 374. See also another case, Well Done against Home Office, Weldon is WELDON. Weldon against Home Office. 1990, 3 all ER 672. See another case. Egg against DG of Parkhurst. Parkhurst Prison. Parkhurst. PARKHURST. Egg versus DG of Parkhurst Prison. And see also the case of R and Self. R and Self, as in myself. R and Self, 1992, 1WLR 657. It's a Court of Appeal case. In the case of Dumbbell and Robot, Dumbbell as in dumbbell and Robot, 1944, 1 all ER 326. Now, in that case, the plaintiff was returning from work, dressed in uniform, and carrying a bag of soap flakes when he was stopped and questioned by the defendant, who is a police officer. He was not taken to the police station and charged with being in unlawful possession of soap flakes, which charge could not be substantiated and was dismissed by the court. I think a lot of us can relate to this kind of a thing with our Nigerian police. The plaintiff, of course, brought an action for false imprisonment. There was no evidence to suggest that the plaintiff had stolen the goods or that he had received them knowing them to be stolen. There was nothing to indicate that. You just picked him up and you took him to the police station. The court held that the police officers were liable for false imprisonment. When the two defendants arrested the plaintiff without a warrant and made no attempt to ascertain that the plaintiff's name and address, they failed to comply with the condition precedent to the exercise of their right to arrest him without warrant and under the statute. You know, there is an exception for police officers to arrest without warrant when they have a lawful or reasonable suspicion of a crime. But they were not able to prove any of these things. So the court said they were liable for lawful imprisonment. In another case, Burton and Davis. Burton is spelled Burton against Davis. 1953, QSR, Queensland. It's an Australian case. Now, the plaintiff was riding in a motor vehicle driven by the defendant. Now, he prevented the plaintiff from coming down from the vehicle at a certain place by driving past in excessive speed. The court held that driving a motor vehicle past and preventing a passenger from alighting at his destination was false imprisonment. I think a lot of us can relate to this. When he shouted, "Onigbongbo," he said, "Oh wow, oh wow." And the man just drove excessively and dropped you at a Butemeta. That was something similar happened in this case. In the case of also Onitiri and Ojomo, as pronounced, Onitiri and Ojomo.
Sorry, ma. Please, ma, we're kind of moving fast.
Good
morning, ma.
Good morning.
Ma, please, I didn't get the name of the case of the one where the driver stops the passenger from alighting at his destination.
Burton and Davis. Burton is Burton against Davis. Burton against Davis is a Queensland, an Australian case. Okay.
Thank
also,
you,
see
ma.
the case of, you're welcome. See the case of Onitiri and Ojomo. Onitiri and Ojomo, 1954, 21 NLR 19. Now, in that case, the defendant magistrate was presiding at a court where the plaintiff was a party in a certain proceedings for an alleged contempt in the face of the court. The defendant ordered the plaintiff to be detained pending the plaintiff's trial for the contempt of the defendant's court. The plaintiff, believing the defendant's detention to be wrongful, sued the magistrate for damages for false imprisonment. I think you should go and read that case and see the ending. Let me just tell you, Sha, in that case, the court held that defendants, as a magistrate, is not liable in any damage for any act done or ordered to be done when acting in his judicial capacity. See also the case of Soji Omotunde against AG. Soji Omotunde against AG. See the case of Riverside. Let me try and pronounce it well. Riverside, but the spelling is Liversidge. Riverside against Anderson. Anderson without H. That is Anderson, 1942, AC 206 HL. In the case of Union Bank of Nigeria Limited and another against Ajagu, Union Bank of Nigeria Limited and another against Ajagu, 1990. One Nigeria Weekly Law Report, part 126, page 328. Now, the plaintiff slash respondent, customer of the first defendant, the appellant bank, on a certain day went to the branch where he operated an account. When he was about leaving the premises, the second defendant, who is the appellant, an employee of the appellant bank, locked the gate leading into and out of the bank premises, in spite of the plaintiff's entreaties to be allowed to leave. The plaintiff spent some time inside the bank premises after the conclusion of his financial transaction. The plaintiff brought an action in false imprisonment. The Court of Appeal held that there was false imprisonment and the defendant, that is the appellant bank, was vicariously liable for the false imprisonment of the plaintiff by its servant. A lot of us can maybe relate with this. So maybe he went to the bank, and when he finished his Union Bank, he finished his transaction. Maybe it was all the security men that deprived him of leaving. I wouldn't know for what reason. And the man had to stay in the bank maybe for 1 hour before he could leave or something for a while, after he must have concluded his transaction. So the man brought an action against him. I think he won in the court of the High Court, but I think the bank appealed. And the court held that, yeah, you falsely imprisoned the poor man, and you're going to do vicarious liability second semester. So, but the court also said that as a bank, you are vicariously liable for any action carried out by the security men or by your staff. So far, he's doing it in the course of official business. Now, so also the case in Queen and Lambo, Sokoto. Queen against Lambo, Sokoto, 1961, WNLR 27. In that case, the accused allegedly caught hold of a girl in the street, took her to his room, undressed her, forced her to kneel down naked, and placed a piece of cloth on her head. And by means of hypnotic trance, she was unable to move or speak. He immobilized her until the girl's father and the policeman who were looking for her arrived at the scene. On request by the police officer, the accused promised to release the girl if he was treated gently. When he did, by calling the name of the girl thrice and by speaking to her in an unknown language, I'm sure it's an incantation, to the policeman, she was thereupon able to speak and move. On being charged to court, the evidence as to whether the accused had locked the door of the room where the girl was found was inconclusive. However, in the High Court, it held that there was false imprisonment. The court found that the accused had no lawful excuse to confine the girl against her consent. In this case, the court held that if one person immobilizes another in a room by hypnotism. He confines that other person in the room just as much as if he had locked the door of the room. The accused had no lawful authority or excuse for confining the girl who did not consent to the confinement. So in a charge of false improvement, it is unnecessary to prove that a person has exercised his power of violation by deciding to leave a place of confinement, but had been prevented from giving effect to that decision. So it is sufficient to prove that he did not consent to confinement. The onus of proving reasonable cause for the false imprisonment is on the defendant. Let's move quickly. Restraint of the person is unnecessary. Physical restraint is unnecessary. Restraint of the person is not necessary. For instance, if you prevent a person from leaving a place, or restraint of movement or confinement of that person, whether in a prison or in an open street or so. Therefore, the offense of thought of imprisonment is not committed once. The offense of or thought of false imprisonment will be committed once the free movement of the person is prevented by any act. You don't need to physically restrain the person. The false imprisonment is any act that prevents liberty or freedom of movement without lawful justification. So you can use street, you can use order, you can use word of mouth, you can even use physical restraint. Then another thing we are talking about is that the restraint must be total. The restraint must be total. I'm sure this particular point was a question. If you look at some of your past questions, I think we used this as one of the questions in one of your past exams or tests. The restraint must be total. For there to be false imprisonment, the restraint of the plaintiff must be total. See the case I gave you earlier on Bed and Jones. Bed and Jones. Where there is a reasonable route, exit or means of escape, there is no false imprisonment. So if kí lorúkọ ọmọ tó ṣẹ̀tàn nísìnyí o Chiedu Anyaoku. So if Anyaoku should come to, maybe you're having a course in LLM office, I said LLM lecture room downstairs, and Anyaoku comes in and decides that he comes in through the front door and locks the door and said, "Oh yeah, Michael, Lawrence, and normally I won't allow you to leave this class today. I'm going to lock you inside." And he locks that front door wherein the lecturer will come in through. But you know that there is another open door just that you step out at the back to the corridor. And that one is wide open. You know that that's not a total restraint. Except now, Anyoku comes in and locks that main door. And Omole and Lawrence, they are inside. Michael now goes to the back door and locks it as well. That both of you are going to show you Pepe today. So essentially, restraint must be total. However, it is not a tort to prevent a person from leaving a premise when he has not fulfilled a reasonable condition on which he entered. I want you to note that. It is not a tort to prevent a person from leaving a premise when he has not fulfilled a reasonable condition on which he entered. Let me give you an example. The first one, okay, let me just give you one example so that we can move quickly. Anyoku went to, Anyoku's, since he's in his warehouse this morning and he's disturbing my class. In his warehouse, he's selling, what are you selling, sir? Maybe spare parts. He's selling Suzuki and Toyota spare parts. So Omole now goes to Anyoku to buy a bumper because he went to buy a carburetor for his car. And because Omole disturbs my car, my class, his car is not a fine car. It's a rickety car. So Omole now goes to Anyoku. Anyoku now gave him the carburetor. Meanwhile, Omole and Lawrence went. So Omole now gave Lawrence, oh yeah, go to the car where we parked it and go and check if it's the same size. And Lawrence now went to check. Omole was there. Lawrence now called Omole, Oga, it's the same size, so we fixed it and it's working. Anyoku now said, yeah, Omole, pay me my money. Say, which money? I'm not paying you. I will pay you when next I come to the market. You know that Anyoku will not allow Omole to leave. So that's an example. So I said it's not a tort to prevent a person from leaving a premise when he has not fulfilled a reasonable condition on which he entered. In the case of Merrin and Graham White's Aviation Company Limited, I've given you that case before. The plaintiff was suspected of stealing some items from the defendant, who was his employer. So two policemen who provided security to the defendant's office asked him to accompany them to the company's office for interrogation. The plaintiff, who did not know what was his offense and was not aware that he was a suspect, agreed to the request. He remained in the office while the two policemen remained outside the room without the plaintiff's knowledge that they were there, and with instruction to prevent him from leaving. He later sued for damage for false imprisonment. The court held that there was false imprisonment and he could claim. His lack of knowledge of false imprisonment at that time was irrelevant. So the restraint of the plaintiff must be total or complete. Therefore, to bar a person from going in there in their direction, but leaving him to go free in a fourth direction is not false imprisonment. That's just, I've said that also. Should I give you the fact of Bird and Jones? Should I? Okay. Okay. In the case of Bird and Jones, let me give you the facts, but you go and read it. If you like, go read it. You meet us in exam hall and you chew your biro. Ayoku, can you hear me? A bridge construction company lawfully stopped a public footpath at Amersfoort Bridge in London. Now, a spectator of a boat race insisting on using the footpath, but was stopped by two policemen who barred his entry. The plaintiff was told that he may proceed to another point around the obstruction, but that he could not go further on that particular place he wants to take. He declined to go in the alternative direction and remained there for about half an hour, and then brought an action in false imprisonment, under false imprisonment. The court held that there was no false imprisonment since the plaintiff was free to go another way. Also see the case of Wright and Wilson. Wright as in WRITHT and Wilson, WILSON, 1699, 91 ER, 1394. Now, the court held that there was no false imprisonment where the plaintiff was able to escape from his confinement after committing nominal act of trespass on a third party's property. This means that the means of escape must, however, be reasonable. The means of escape must, however, be reasonable. If the person is able to escape, maybe through a very tiny window that is very dangerous, and probably there are nails there, that will not be a reasonable one. Therefore, a means of escape which will endanger the life of the plaintiff will not be an excuse to the defendant from a claim of false imprisonment. However, when a means of escape is available which will not endanger life or cause a defendant, the plaintiff, to be maimed or maimed rather, there will be no false imprisonment. If a person is on a premises of property and is denied exit or facility to live, there is false imprisonment. There are so many exceptions. Let me try. I'm trying to see how we can run fast. Okay, let me read. Let me do this. So another one is if a person is on a premises or property and is denied exit or facility to live, there's false imprisonment. Unless the restraint is an insistent on a reasonable conduct. See the case of Warner and Riddlefold. Warner, W-A-R-N-E-R. Warner against Riddiford. R-I-D-D-I-F-O-R-D. See also the case of Head and Warday Steel. I won't read I won't tell you the facts of all these cases. Go and get them. Warner and Riddleford. Riddleford is R-I-D-D-I-F-O-R-D. 1858, 140 ER, 1052. See also the case of Head, as in head of cattle, H-E-R-D, Head against Warday Steel Coal and Coke Company. Well done. Head, H-E-R-D, against Warday Steel Company, Coal and Coke Company. Wardale is spelled W-E-A-R, W-E-A-R-D-A-L-E. W-E-A-R-D-A-L-E. Wardale Steel Coal and Coke Company Limited. 1915 AC. Let me just give you the fact of that case. Now, in that case, that were the Hand and Walden. A miner went into a mine as usual with the understanding to work for the specific period of his shift before coming to the surface. You know, you go deep inside. Now, a dispute arose between him and his employers in the mine pit, while down the pit. He demanded to return to the surface, but the employer refused to grant him the use of the hoisting cage for him to come to the surface, and he was stranded in the pit for about 20 minutes. It was held that there was no false imprisonment. The miner entered the pit of his own free will, and the employers were under no duty to bring him to the surface until the end of his shift. Well, okay, let's go to another point. Another point is restraint for the shortest period of time is false imprisonment. Restraint for the shortest period of time is false imprisonment. The shortest period of restraint or confinement is false imprisonment. See the case of Hand and Warday that I gave you before. See also the case of Olding against Chief Constable of Lancashire. Chief Constable of Lancashire. 1986. Holding, H-O-L-D-E-N, against Chief Constable of Lancashire. 1982, 3 all ER. Therefore, no fixed period of time is necessary. No fixed period, so it need not to be 1 hour or 10 minutes or 5 minutes. However, a false imprisonment that is for a very brief time may only attract nominal damages. So what I'm saying essentially is that the timing, even though that there is the restraints for the shortest period of time is false imprisonment, if it's just briefly, it will just go to the compensation or to the nominal damages that the court will give to the claimant. So another point we are discussing is contact or use of force are not necessary. Contact and use of force are not necessary. Now, in committing false imprisonment, it is not necessary that force be used on the plaintiff by way of battery, like I mentioned earlier on. There need not to be any physical contact. A threat to use force on the plaintiff whereby the plaintiff is restrained by fear is sufficient. So when you shout, you scream, or you threaten, it is sufficient. Therefore, an order such as "stay there" or "I'll shoot you" may be evidence of false imprisonment. The use of authority, intimidation, threat, influence, order, trick, hypnotism, pronouncement of arrest, or request to follow the tortfeasor or the defendant is enough. So where a police officer wrongfully orders a person to follow him to the police station without giving him the option of refusing to go, and the person is obeyed, the police officer may be liable to false imprisonment, particularly when he's unable to subsist, like the case I gave you earlier on, when he arrested somebody for carrying a soap flakes without any lawful justification. See the case of Igoro and Anebunwa. Igoro, Aigoro, Igoro and Anebunwa, Anebunwa, 1966, NNLR 87. Now, in that case, let me just give you the facts. The plaintiff was a train station. The plaintiff was at a train station about to board a train when the defendant called on the police to assist him to prevent the plaintiff from leaving on the train. The policeman then invited the plaintiff to come with him to the police station. No physical force was used to restrain the plaintiff. The court held that there was false imprisonment. The plaintiff, by being asked to come to the police station, was not doing what he wanted to do, nor acting of his own free will. Excuse me. See also the case of Clark and Davis. Clark and Davis. So let's move on. Another one is mere words. Mere words may not, and I want you to underline not, mere words may not amount to false imprisonment. So if I shout to all of you, Anyaku, you must not leave Alaba Market, your shop today. Mere words may not amount. I want you to underline two words in this sentence. Mere word may not. I want you to underline may and not amount to false imprisonment. Generally, mere words without more do not constitute false imprisonment. So you understand what I say? Mere word without more, without more, may not constitute false imprisonment. So when I shout to Anyaku, because you disturbed my class today, you must not leave your office today. That's just mere words. There is no more to it. But if I go further and said, I'm going to send somebody who will be monitoring you. If you leave that office, I'm going to score you 0 in this course. I've added threat. I've added something that I'll be monitoring you. But if I just say, Anyaku, if you leave that Alaba shop today, you're going to score 0. So look at the case of Gina against Pix or Sparks. Gina is Genner against Sparks, Sparkes, 1704 91 ER 74. Now the defendants, who is the court believe, informed the plaintiff that, okay, don't let me go. You go and read it. We have a lot to do. See also Rusen and Lucas. Rusen is RUSS, RUSSEN, and Lucas, 1824, 171 ER, 930. So mere words may not constitute arrest. And if an officer say, I arrest you, and the person runs away, it is no escape from custody. Let me leave that. Another thing we're going to be considering, another point is knowledge or by the plaintiff. Knowledge by the plaintiff of the false imprisonment at the material time is irrelevant. So essentially it means that even when you are being falsely imprisoned, even when you do not know at that time that you are being falsely imprisoned, is irrelevant. So it is not necessary for the person who is restrained to know at the material time that he was detained, restrained or confined or being prevented from leaving. It is sufficient if he is informed of the false imprisonment later. So maybe you went to the hospital or in the bank and the security now said, please, can you follow me? And you followed him. And it took you to maybe a room and they just left you there. Probably there is a CCTV camera there. Maybe they are now trying to look at you through the CCTV camera, trying to check you. Maybe they're suspecting you did something. Maybe after like an hour, you know, say, you people, please, I need to go. They now say, okay, go. So, you know, at the time they say, excuse me, follow me. You did know that you were very falsely imprisoned. So the person, a person may be falsely imprisoned while unconscious. Okay, let me emphasize this. A person may be falsely imprisoned while unconscious, asleep, or otherwise unaware of what is happening, etc., etc. The person need not be aware so long as the false imprisonment is a fact or it is complete. If he learns about it from another person, he is entitled to bring an action. See Merrin and Graham White aviation that I told you people, that I gave you earlier on. See also Murray. No, let me say Murray because of spelling. Murray against Minister of Defense. Murray is Murray. Murray against Minister of Defense, 1988, 2 all ER 521. Now, you have to contrast this case with Erin against Boyle. Contrast the case of Murray against Minister of Defense. Contrast it with the case of Erin against Boyle. Erin is H-E-R-I-N-G against Boyle. Boyle is spelled B-O-Y-L-E. I think I've given you before too. I don't know. Now, in the case of Delegiwa, okay, let me tell you the facts. In the case of Delegiwa against IGP, unrepresented, it's an unreported suit rather. Delegiwa against IGP. The plaintiff, who was a top flight journalist and columnist, was arrested and detained by the police. He brought action for enforcement of his fundamental rights to personal liberty and for damages. The court held that the defendants were liable. The plaintiff was entitled to his freedom, and therefore a sum of 10,000 was awarded. Then 10,000 was big money because this was 1984. For the unlawful arrest of the detention of the plaintiff, being compensation for the false imprisonment, restraint, loss of liberty, and the indignity to which he was subjected. I want you also to see the case of Shugaba and Minister of Internal Affairs. I've given you this case before. If I were you, I'll read that case as well. See also the case of COP, Ondo State, against Obolo. COP against Obolo, 1989. 5 Nigeria Weekly Law Reports, part 120 at page 130. I won't give you the fact. Go and read it. Okay, let me give you. COP Ondo State, Commissioner of Police Ondo State against Obolo. Now, in that case, the plaintiff respondent was routinely picked up as a suspect. Whenever there was a case of robbery, he applied and obtained leave of the court to enforce his fundamental rights against the police to show cause why his right to personal liberty should be breached by being unconstitutionally and unlawfully arrested and detained on diverse dates without being informed of the offense he had committed or charged or brought before a court of competent jurisdiction. You just go and pick him, just go and pick him. On appeal, the Court of Appeal held that the fundamental rights of the respondent had been infringed without reasonable and probable cause, and the court awarded the cost of 17,500, which was big money also in 1989, was awarded for the unlawful arrest of the detention of the respondent. In that case, Salami JC as dead delivered the judgments and stated that the test as to what is reasonably believed that the respondent had committed an offense is objective. It is not what the appellant considered reasonable, but whether the fact within their knowledge at the time of the arrest discloses or disclose circumstances from which it could be easily inferred that the respondent committed the offense. At times when I look at these cases, this was when Nigeria was, there was a bit of sanity with the police and the law enforcement officers. Because presently, only God knows how many hundreds of people are in this situation and nothing will be done about it. See also the case of Oteri and Okorodudu. Oteri and Okorodudu. So another thing we're going to be considering in false imprisonment, another point we are noting is that the burden of proving the legality or constitutionality of the arrest and the imprisonment is on the appellant. See the case of, I've given you Oteri and Okorodudu. Another point we are going to be considering is, this is that 1038, we need to move fast.
Sorry, we didn't get the other case that you just called. I mean, the other point.
I said the burden of proving the legality or constitutionality of the arrest and the imprisonment is on the appellant. Okay? Another one, unlawful arrest is a trespass to person. Unlawful arrest is a trespass to person, which, unless it can be justified, usually renders the tortfeasor liable. Unlawful arrest is trespass to person, which, unless it can be justified, usually renders the tortfeasor liable. The court will not allow the police to seek cover under the provision of the Criminal Procedure Act when they derogate from the procedure laid down by the law in the arrest or prosecution of offenders. So this is just to protect people from randomly being picked by police. You can see the case of Ikone against the COP. Ikone is IKONNE against COP. 1986 Nigeria Weekly Law Reports, Part 36, page 473. It's a Supreme Court case. You can see also the case of Enwere. Enwere against COP. CEN. Enwere is spelled ENWERE against the police. 1993. 8 Nigeria Weekly Law Reports, Part 299, page 333. It's a Court of Appeal case. Now, I want to, talking about this, there is a question here. And I think I even like this question. There is a question here. You know, I said that unlawful arrest is a trespass to a person, which, unless it can be justified, usually renders the torturous liable. So the question is this: who is liable? Okay, don't let me ask the question first. Let me give an instance. Michael, Anyaku and Michael. Sorry, 1 minute. Okay, let me give you an instance where Anyoku, because Anyoku is a big boy in Alaba, so he has money. He cooks, you know, he has money, he flaunts money, he lives large, he's a big boy. He wants to bam bam, he wants to roll with the big boys. Michael lives near him. And Michael will just keep looking at Anyoku. That, why is this Anyoku living large? This boy must be a Yahoo boy. Yeah, I guess he's a Yahoo boy. He must be a Yahoo boy. So Michael called the police, or EFCC or whatever that. He calls the police that, you people come, there's this boy in my living on my estate. His name is Anyoku. He's a Yahoo boy. Please come and pick him up. Or whatever examples. So the question is, who is liable? The police or the caller of police? Now, a person may be liable for false imprisonment if he himself affected the arrest, or in accordance with the general rule that he who instigates another person to commit a tort is a joint tortfeasor. So for procuring or actively promoting the commission of a tort, when an arrest is wrongful, both the person who instigated the arrest and the person or the police officer who effected the arrest are joint tortfeasor. Both of them are joint tortfeasor, except the arrest was entirely at the decision or discretion of the police. So I think this exception is a protection for whistleblowers. So because if you suspect something and you tell the police, I don't think the next thing is for them to just come and pick people. They're supposed to conduct a reasonable form of investigation. So in deciding who may bring an action for false imprisonment, the deciding factor is who was active in promoting and causing the arrests. Therefore, a person may be liable for false imprisonment by effecting the arrest or confinement personally or by instigating another person to commit the tort. In that case, you will be seen as a joint tortfeasor for procuring or actively promoting the commission of a tort. When an arrest is wrongful, both the police and the person who instigated the arrest are joint tortfeasor, except the arrest was entirely at the discretion of the police. Please, 1 minute. Let me just catch my breath. All right, sorry for the break. I just needed to catch my breath. So let's talk about defenses to trespass to person, and it is quite many. Let's see if we can finish that so that next class we can move on. If we can't finish, we'll leave it till next class. Let me see if there's something I've missed out. Let me see. Okay, let's talk about the defenses, and there are quite many. Number one, you can talk of self-defense or justification. Self-defense or justification. See the case of Turner against MGM Pictures Limited. Turner is spelled Turner, Turner, against MGM Pictures Limited, 1950, one all ER. See also the case of Lane and Holloway. I think I've given you that case earlier. Lane and Holloway. Now, the only requirement when you talk of self-defense is that the requirement for this is that for it to be successful is that the self-defense should be reasonable or proportionate. Reasonable and proportionate. So that is one. Number two, maybe defense of property. I was trying to think of a situation in which self-defense, where maybe somebody is trying to hurt you, or you think somebody is trying to hurt somebody, maybe your wife or your sister, and you lock the person up. I don't know. So that would be a self-defense. And another one, the second one is defense of property. Defense of property. A person may commit commensurate or reasonable trespass to another person, such as assault, battery, or false imprisonment, in order to protect his property or see what I'm taking now. The defenses I am taking, maybe I should explain that, is defenses to trespass to person, not just to false imprisonment. Because now I think we are through with assault, battery, and false imprisonment. We've explained everything, what they are, their essentials, and we've highlighted quite a number of cases. So we're now talking about the defenses. We're going to talk about the defenses to trespass to person, and we're going to talk about their remedies as well. We've talked about the first one, self-defense or justification. So another one is defense of property. Like I said, a person may commit commensurate or reasonable trespass to person, such as assault, battery, or false imprisonment, in order to protect his property or the property of another person, which he has a moral or legal obligation to protect. Maybe the property of your wife, the property of your person, of your child or your spouse. See birds and the case of bird I gave you earlier on. See Amins and Stoke Podge golfs. I'm not sure of this. See Amson and Duke of Rutland. See Amson and Duke of Rutland. Therefore, reasonable measure may be taken or reasonable force may be used to eject or deter a trespasser from entering a property. Now, another one, number 3, consent of the plaintiff. The consent may be expressed or implied consent. Maybe in a complete defense when you talk of trespass to person. Consent is a defense when it is obtained freely in the absence of duress, fraud, trick, deceit, force, or undue influence. So when the consent is obtained without this, it's a complete defense. Now, consent is deemed in sports, for example. So when you're having boxing or wrestling or anything like that. So accordingly, consent is often a defense for injuries suffered in sports, maybe sporting events. As a general rule, participants in sports are deemed to consent to reasonable contact within the rules of the game, except where the act is unreasonable, involves considerable hostility, or is deliberate. So when you are doing table tennis, and the person you know that probably, or you are doing even you are doing a race, you expect that probably you're going to touch each other, you may bash each other. But when it's beyond that, and probably the next person pushes you, you know that it is not within the rule of that game. See the case of Condon and Bassi. Condon, C-O-N-D-O-N, and Bassi, B-A-S-I. 1985, 2 all ER, 453. Now, number 4, medical treatment. Medical treatment. Medical care and medical surgery. In medical care, a patient is usually deemed to have consented to normal course of treatment for his ailment, except where such treatment is outside the scope of the patient's express or implied consent. Therefore, consent to medical care is consent to assault, battery, and false imprisonment. But it is not consent to negligent medical treatment. As a result, treatment or surgical operation carried out in good faith with reasonable skill, knowledge, and care for the benefit of the patient is a lawful excuse in a claim for trespass, because these are contacts which are usual for the plaintiff's benefit. So when you went to a doctor's and he said, okay, lie down, let me check the area, let me feel it, let me do this, that is within the reasonable course of treatment. Conscious adults who are about to undergo surgery may require to sign consent form, you know that one, when it comes to medical treatment, which are usually drafted in standard form. So in a treatment not involving surgery, a patient is deemed to give implied consent by consulting a medical doctor. So when you went up to his office and said, doctor, I'm having stomach ache, and he says, lie down, let me feel your palpitate your tummy. By you going to consult with him, it's deemed that you have given the implied consent. Adulthood requires emergency treatment, whether or not they are conscious, are deemed to give implied consent to treatment because of the emergency and the need for doctor to quickly intervene and to save the patient from grievous harm or loss of life. A defense of necessity will avail such doctor. CF against West Berkshire HR. F against West Berkshire, BERKSHIR, I think Hospital Authority, HR, 1989, 2 all ER, 549. See also the case of Bolam against Frem Hospital. Bolam against Frem. Okay.
I just go back to. Are you still in class? Because we are housing law now. I don't know.
No. We'll stop at this space. This is 11 o'clock. Don't let me overstay my welcome with you. Thank you so much. So class will continue on the Monday by God's grace. Enjoy your week.
Wait, ma,
Thank you, ma.
Bye-bye. Thank you, ma'am.